Walker. Mr. Maher, whenever you're ready.
Good morning, and may it please the court. Thomas Maher on behalf of the appellant Charles Walker. Mr. Walker is currently serving a sentence in excess of 400 months for his alleged role in the robbery of two different K jewelers, one in Elizabeth City, one in Garner. There is no doubt that Mr. Brown and Mr. Maynard were involved in these robberies. They were on video, entering the stores, brandishing guns. The question before the jury was whether Mr. Walker played a role in organizing or executing those robberies. The three first issues I briefed are all related in the sense that they are placing the thumb on the government side of the scale and argue unfairly. The first issue had to do with the impact on three of the employees of these stores who went through the robberies. The second two are related, and they are opinion evidence. The second one was store employees offering their opinion on Mr. Walker's role when he was inside the store in Elizabeth City.
Based on their personal observations of what happened during the robbery, that was their testimony, just telling the story. So how is that inappropriate?
Well, it was based on their interactions. It is inappropriate because the opinions they offered, for example, one of them testified that Mr. Walker was the decoy man. That wasn't simply an observation.
That it appeared to them that he was acting as a decoy,
correct.
Not that he was.
Well, in their opinion, he was. I mean, she testified that she thought he was the decoy man. That, of course, was the government's theory of his role in entering the store.
I thought that was testimony that the defendant's counsel elicited.
That answer came in response to a question from the defense counsel, but he had actually asked about the leadership role between Mr. Brown and Mr. Maynard. In answering that, she volunteered that Mr. Walker appeared to be the decoy man. He had not specifically asked about Mr. Walker.
But he asked about the relationship, right? That seems to be the relationship. I'm watching a football game and I see two guys running a route, and I said, what's the relationship between those two guys? The guy running the deep route was the decoy. They were throwing the out route. Like, that seems like to me that's asking the relationship, and she gave you the answer that you wanted. Or maybe didn't want, but that you asked for.
I wasn't trial counsel, but in reading the question I believe was directed towards the two people, Mr. Brown and Mr. Maynard, who clearly were robbing the store. They were the two that had initially gone in, left, and then came back with the guns, and he was trying to ascertain which of those two was the leader. In responding to that, she volunteered that the defendant, Mr. Walker, appeared to be the decoy. So I don't believe that it was invited by the question. I believe it was in response to a question that went to the role of the two other people who were in the store actually robbing the store. And the testimony that he was acting afraid came during the direct of the other employee. Both of those went to the issue. Was he there in some innocent role like he later testified, or was he in there playing the role as described by his co-defendants and as urged by the government? And do not believe that is the type of lay opinion that somebody just watching somebody in the store should be entitled to give. And it went to a very crucial issue in the case, which is what was Mr. Walker's role? He testified about being in the store. He denied that he was involved with his two co-defendants.
Well, given the wealth of other evidence against Mr. Walker that indicates what his role was in the robberies, how is this not harmless?
This is not harmless. There was clearly a fair amount of evidence introduced by the government. The principal evidence came from his co-defendants, who described in detail what they claimed his role was in recruiting them and arming them and planning this.
Well, there was also cellular data and GPS tracking data and things that corroborated what they said, like the charger being tied to the phone charger being tied to the tree where they left the stuff. There was all kinds of other evidence against Mr.
Well, there certainly was a great deal of
Walker.
evidence tying him to his co-defendants. The GPS data, the cell phone data showed that he was traveling.
And the vehicles that were used were Mr. Walker's.
Well, the Mercedes was clearly his, and there was a video that shows a Mercedes being followed by a van. He denied and testified that he had nothing to do with the minivan. And Mr. Sparks claimed that he had sold that to Mr. Walker. Mr. Walker testified that simply wasn't true. He testified in detail about his connection with these people, that he knew them, that he recognized that they were in the same places, but testified that he was not involved in the
whether it was he was involved in the robbery or all of these things were colossal coincidences.
Well, I mean, that's what the government's argument would be, his position, of course, and he testified. And ultimately, the jury isn't choosing between his testimony and the government, but whether they are convinced beyond a reasonable doubt by the government's evidence. And the most damaging evidence, if you believe it, was from his co-defendants. But they obviously had plea deals, they had extensive criminal histories, they stood to benefit. Both of them were on tape in both robberies with guns, so they had no defense.
You raise a number of issues. Which do you think is your strongest point?
If I had to pick the strongest, I would say the third issue, which is Agent Robertson's testimony concerning the jail calls.
Yeah, I agree with that. So maybe, how about you argue that one?
What happened here is Mr. Walker was talking to a woman, last name I believe was Baldwin. She was serving time in the North Carolina prison system. She had nothing to do with these robberies, as far as I can tell. So they were these conversations that were recorded, and the government obtained them. And the FBI agent in charge of the investigation subsequently listened to these and was allowed to testify to what their meaning was in connection with
And
both.
was he testifying as an expert witness or a lay witness?
As a lay witness. He was
Okay.
not tendered as an expert. And that makes a crucial difference in terms of how the court should rule on the admissibility of his opinion. And it was,
Does it make it cool if he had been certified and testified as an expert? Could he have given these? I mean, isn't that the sort of the conversations that we've allowed with an appropriate background, and maybe he had it, maybe he didn't, all that. I get that. But if he was qualified as an expert, that he could have done this type of testimony. But your angst is that they didn't qualify him, and I agree they didn't qualify him.
right, well, it certainly made a difference. Had he been qualified as an expert, I think some of the conversations he may well have been able to give expert testimony, but some of them, I think, would be beyond being an expert. For example, I don't know if there's any expertise that allows you to interpret a discussion about a basketball game as being about a robbery. There's no specific-
Right, but that
Well,
seems
go ahead.
that seems to me the rub here, right? Because that's what I was trying to get at a little bit. Because when you look at the conversations, part of them do seem subject to sort of expert testimony, but parts of them do look like lay opinion testimony, right? Because they really are interpreting, the words in light of some sort of common sense and background knowledge. And that does strike me as sort of appropriate lay opinion testimony, but, hypothesize that I agree with you that some of it looks like agent expert testimony. How are they supposed to do both, I guess is the rub.
Well, I guess in theory, he could have been qualified as an expert and given both expert and lay opinion testimony.
So long as he made clear which he was doing at what time.
In other words, some of it would have been justified as an expert, some might have been justified without being an expert. Here, he was never tendered as an expert. He did, I will say, in talking about this basketball game conversation, rely on his experience and expertise in interpreting that. So he appeared to, at that point, kind of shift over.
Wasn't there also lay testimony from Mr. Maynard about the basketball game conversation?
He was apparently in the car at the time of the conversation, and he testified that this was, in fact, a conversation about a robbery. He had, of course, incentives to police and government, reasons for the jury not to believe him. Mr. Walker testified that no, this was not about a robbery.
I'll say on the basketball game seems to be the conversation that's the most veiled, right? It really could be about a basketball game unless someone told the jury otherwise. I think there was a July conversation, a couple of those where I was honestly kind of confused about why anyone needed to interpret those. It seemed like just, giving the definitions of English words that didn't seem particularly veiled, but I may have missed something there.
No, I don't think you missed something. I think there were two conversations in July, both I think took place on the same day, and the agent testified to a number of things, some of which were just English words, but some of which weren't. So, for example, I believe he testified about a comment that he goes straight to the back room, and he said that was about going to the back room.
Straight to a back room.
That other than he is now endorsing that as part of a robbery when Mr. Walker said no, it was about gambling. He did, I believe, talk about his lineup, meaning that he's a leadership role in the robbery in the Joint Appendix 594.
Well, then Mr. Walker also chose to testify, and didn't he explain what, from his perspective, what all of those things meant?
Yes, he addressed, I don't know that he line by line went through each of them. He talked about Charles Xavier, he talked about the backroom, he talked about the basketball game. And of course, the jury had reasons to not believe what he said. And when an agent is kind of taking the other side and saying, no, a basketball game was about a robbery, and then you have Mr. Walker saying, no, it's about these Rutgers games, which are in fact a real thing. We bet on basketball, that allowing the agent to give that testimony fairly tipped the scales. And I will say that not all of these were objected to at trial. The basketball game, for example, there was no objection. But a number of the interpretations of the July 12th conversation, there were contemporaneous objections. And so, at least as to those, not all.
But was there ever an objection that this was impermissible lay testimony, that it should have been expert testimony? I thought the objection was that the officer didn't have the requisite knowledge because he was from a different part of the state.
That was the primary argument made, that the defendant was from Greensboro, the agent had served in the eastern part.
From Mania.
And the argument was, to the extent this was relying on understanding slang, he didn't have the geographical knowledge. The specific argument that I made in my brief was not at least clearly articulated before the trial court. But as the agent testified, there were at least general objections to a number of the questions for the July 12th conversations, including interpreting tools and even firearms. So I understand that at least some of this may be under plain error. I would argue that not all of it should be viewed as plain error. There were, in fact, objections. And the reason this is important goes to the fact that Mr. Walker testified and Mr. Painter testified. The jury was going to have to decide, based both on the content of the conversations but on the testimony given, what these meant. If they believed that was a conversation about a robbery, there really wasn't much else they needed to decide on the case. If he's describing a robbery, he's guilty. And of course, having an agent get on the stand and say, in essence, Mr. Maynard telling the truth, it is a robbery. Mr. Walker later testified.
And that goes back to my question earlier about all of the evidence against Mr. Walker. You might have a better argument if the evidence was really a Agent Robertson says versus Mr. Walker says, but it was Mr. Walker says versus Agent Robertson versus, and the witnesses and the vehicles and the cellular data and the GPS tracking and all the other co-defendants who testified and the screenshots of the alleged threats. So I'm not sure you can get past harmless error.
And I will say, when you've got co-defendants who are specifically saying, Mr. Walker recruited us, he provided the guns, he provided the plans, the rest of that evidence certainly corroborates a lot of the kind of logistical aspects of what they said. Other than these phone calls, it doesn't directly corroborate that Mr. Walker was the leader, played a role in organizing these robberies. It placed him with them, and he testified that, in fact, they followed him, that he was present when they came into the store. A jury might not believe that, but they might give them reasonable doubt, and that would be a reason to vote not guilty. So these conversations, in particular, were important because they were the direct evidence from Mr. Walker's own mouth that the government says, in essence, were admissions to being involved, not just being involved in the robbery, but to actually being a leader and providing the firearms, which were the tools. So I understand that there's a significant amount of evidence, but the quality of that evidence was primarily from the co-defendants and not the rest on that. If there are no further questions, I will.
All right, thank you. You have time in rebuttal. We'll hear from the government. Ms. Fritz.
Good morning. May it please the court, Christine Fritz on behalf of the United States, asking you to affirm the judgment of the district court. To begin with, I want to focus on the overwhelming evidence against the defendant. And your honors have focused on some of that. We have obviously very compelling testimony from the co-defendants. We have the historical cell site data that tracks these individuals traveling together, especially when coupled with the Chamber's GPS tracking. You have the very unusual route to Virginia, Elizabeth City, Edenton, tracking back after they ran out of gas on their way out. We also have telephone records and connections, and I think that that's something that's important. there was evidence that the defendant was speaking with, or his telephone was connected with Maynard's telephone during the actual Elizabeth City robbery. Similarly, Agent Sutton testified about how there were phone calls between the defendant and Chris Brown's telephone right around the same time of the Garner robbery. You have the traffic camera footage.
Yes, and given all of this evidence, then what was the relevance for the government to elicit from the victims how this impacted them days and weeks and years later?
How the victims were feeling in the aftermath of the robbery, it is relevant to whether a reasonable person in their shoes during the robbery would have felt the intimidation.
And they had already testified as to how they felt during the robbery, that they thought they might die, that they were afraid. So that argument doesn't hold water as to the reason for them testifying as to how they felt after the fact, other than to unduly prejudice Mr. Walker.
I think I would suggest that the immediate aftermath of the robbery, I think that is all relevant. I do think that the further in time you get.
They didn't testify just as to the immediate aftermath of the robbery.
Well, I think that if you look at the questions asked, for example, of Ms. Bene and Ms. Swain, it was, how did this affect you? And I absolutely acknowledge it would have been preferable for there to be a temporal limitation or some kind of focus in how that question had been asked. But again, it is relevant as to, because it can be probative of what their experience was during the actual robbery.
Right, which they had already testified to.
And for example,
Help me understand why afterwards. I take you to sort of be saying, yeah, you shouldn't talk about like not being able to sleep 6 months later, but tell me why, and which I think you're obviously right to sort of concede on, but why would it be relevant if the question had been asked more precisely and said, all right, that night, how did you feel that night after it was over? Help me understand why that would be relevant. Might still be 403 problem, but what's the relevance of that?
well, one of the elements of the robbery is that it was accomplished by force, violence, or
Intimidation,
intimidation.
yeah.
So and of course that is an objective standard, but how the individual who experienced the robbery is subjectively feeling, both during and I think in the immediate aftermath of the robbery, is probative of, for example, the degree of fear, the degree of intimidation. And I acknowledge that the further
Weren't guns used in these robberies?
yes.
What more needs to be said about force, fear, or intimidation?
Well, and in the Hendricks case from, I believe, the Second Circuit, that was also a case for guns.
Right, and that's not a good case for the government.
There are.
I know you cite that, but that actually weighs more in favor of appellants, because in Hendricks, the Second Circuit said that testimony concerning the impact of the robbery weeks and months after the crime has undisputedly ended was only minimally probative of the element.
And I think it does go to show the relevance. I mean, they're saying it's probative, perhaps minimally the further you get out of time, and I think then you run into the 403 balancing. But for example, if you look at Ms. Bene's testimony.
And do I take you to be arguing before us that, yes, relevant under 401, but the can't sleep 6 months later, you're sort of conceding that's like a potential 403 problem, but is not a plain error problem that requires reversal.
And I do also think that highlights the importance that if there had been an objection, I think that would have affected the information that was being elicited. And for example, with Ms. Bene, one thing that struck me, if you watch the video, there's a portion where Brown is attempting to comfort her, and he's touching her. And so she said that she testified that was very upsetting to her. It made her feel disgusting. And her testimony about.
Yeah, but that's not intimidation, is it? I mean, I get why it's disgusting, and I get why it upsets her, and I get why at sentencing that would be powerful evidence to give to the judge to drop the hammer. right? All of those things I totally get. What I don't get is what that's got to do with intimidation.
I think that when you have one of the robbers who are testifying that they were trying to comfort the victim, trying to perhaps make it less scary, I think that that might be probative of the intimidation. And again, I'd like
But isn't that the opposite, right? I mean, at least if she's saying he was trying to comfort me and that made me feel like disgusting, not scared, but disgust. I mean, it's a little bit of a difference, right? I mean, it's got a slightly different undertone.
A little bit, but I think it underscores the impact of the whole experience on her. And I also think that ultimately, when you look at, for example, Benet and Swain, the government, after this testimony was elicited, the government then again focuses on, were you able to go back to work? Why not? I was afraid. So, and I think that also this was not objected to, so it's under a plain air standard, and the evidence is overwhelming.
Yeah, that's your best argument.
I would agree with that.
Can you talk a little bit about the expert issue too? So, I mean, we sort of have a number of cases over a fairly long period of time now where we keep saying, hey, government, when you've got an agent who's testifying about the meaning of language, there are lots of things that you need to pay attention to, and qualifying them as an expert in an appropriate manner, ensuring that their dual roles as a fact witness and an opinion witness are separate, understanding that you can have lay opinion and expert opinion, but you got to be clear that you're separating them. And this strikes me as sort of the poster child for doing none of those things.
I think that when, in reviewing a lot of those cases, for example, the Johnson case, the agent whose testimony was problematic in the Johnson case, he was called simply to testify only to the meaning of recorded telephone conversations. He wasn't involved in the surveillance or the investigation. Here, we have the individual who was investigating from the inception. And I think that when you look at the small part of his testimony.
Did he listen to all of the telephone conversations?
He testified that he listened to many telephone conversations. He didn't give a specific number, but he said that he listened to telephone conversations that the defendant was a part of. He listened to the phone conversations from associates of the defendant, not necessarily that the defendant.
Did he listen to them in real time or after the fact?
These were after the fact. These were recorded telephone conversations. And I think that it would have been helpful, and it would have perhaps enabled the government to more, to give an expert notice. But again, this wasn't objected to on the basis that this is an expert testimony. And if you look at the testimony that this agent gave.
I don't see how it could be expert testimony. Anyway, this isn't, even with training, this isn't the sort of expert testimony we see in drug cases where there's particular lingo connected to particular drugs or drug transactions. These words, I don't see how any sort of training could have made you an expert.
Well, and I think that that's why it was always being discussed in the context of lay opinion testimony, that this was sort of, when the speaking about the slang words first came up, it was during the charge conference where the government forecasted that it expected to introduce lay opinion testimony. The court indicated that it was not going to allow certain testimony about the handwriting, but it was going to allow the testimony about what certain slang words meant.
But we have said that slang, not just slang with respect to drugs, but slang in general, can be the subject of an agent's expert testimony under at least some circumstances. Whether you could have met those requirements here is a different question. But I mean, we have said that slang is something that is subject to
Yes.
expert testimony.
And it can be subject to expert testimony. And I think that we perhaps could have offered this individual as an expert.
What are the slang words
Well, and that also goes to
that are relevant to?
the specific words. They're very limited. So you have the first July 12th call. There was the line about going in because it's my lineup. You have the reference to Charles Xavier, which I don't think is slang, and he's basically identifying that as the leader of the and then you have the reference to tools. So that's the first call.
Wait, the Charles Xavier point. I mean, that's sort of the interesting idea, right? Because like I don't know who Charles Xavier is, right? I mean, maybe other people do. I mean, I do now based on this case. But when I read it, I had no idea who Charles Xavier was. I actually sort of assumed he was a basketball player or something. But so how does that information get across, right? So I mean, how should the government? Take this case off, but how should the government introduce that information, right? So they've got Charles Xavier. They believe that that's a reference to the leader of the X-Men, and that therefore means that, you know, he's indicating that he is the leader. What is the best way for the government to get that in? Because on the one hand, the fact that Charles Xavier is the leader of the X-Men requires like a movie background, maybe. I mean, my clerk could tell you, I'm sure, but like I don't know that. But then also you got to then translate. You know, Charles Xavier is the leader of the X-Men means that he's representing that he's a leader, right? I mean, on the one hand, that's expert testimony, but it's not really an agent expert. It's like pop culture expert.
I don't think that is, I would not consider that expert testimony. I think that was just his general knowledge and awareness. And
Right, but is it something within the like knowledge of the ordinary, you know, person? And I don't know. Charles Xavier, it strikes me is in a certain demographic that might be well within their knowledge, right? I mean, we talked to John back there. John probably knows exactly what that is, but the rest of the demographic has no idea who Charles Xavier is.
I think that I would draw from this court's case language, and the question is it the sort of expert testimony resulting from a process of reasoning which can only be mastered only by specialists in the field? I think somebody who watches that movie can figure out who Charles Xavier is. I do think it's helpful. I know that in my office when I was preparing for this moot, some people did not know who Charles Xavier was. In terms of the meaning of this, I mean, the defendant even talks about, I refer to myself as Charles Xavier. It's a figure of speech. I think also when you listen to the conversation in context, I don't believe it was necessary. I think knowing that Charles Xavier was the leader of the X-Men is useful information, but if you continue to look at his words, he says, you know what I'm saying, and I orchestrate. I'm the mastermind of all the doors. So I think that he's also, in context, he's...
Right, but in order to explain that to a jury, you've got to bring in outside information. And that's what we think of as being an expert, right? Is that like you're bringing in some outside information, and a pop culture reference, you know, strikes me as like an issue of expertise, and you need to bring in like the 19-year-old intern and get them to testify. Yes, everybody in my generation would know that Charles Xavier is an X-Man or whatever he is.
Witnesses offer, though, lay opinion, drawing from their life experiences all the time. So again, I don't think that this is, you need a film expert to be able to speak to this. So I think that anybody who had watched this movie or was familiar with the X-Men could say, oh, Charles Xavier, he's the leader of the X-Men. I don't think that is the type of specialized knowledge that Rule 702 is getting at. And if I can, to look at the other calls, the second call from July 12th, there was simply the reference to straight to the back room. The defendant's mind and focus was on the mission and the use of the word orchestrating, which again, I don't think it was really necessary to define orchestrating. It was used in its conventional.
Yeah, none of that strikes me as something I need help understanding.
Yes, and I mean, if you listen to the telephone calls, I mean, in both the July calls, the defendant talks about orchestrating. So that's sort of a word that he liked to use. And then for the October 12th phone call, you have the basketball game. And the testimony was that was oddly cryptic, even for a jail call, to be speaking about such an innocuous subject in that kind of way. And then also when you looked at the timing and then how certain things were described and how they correlated with. Now, the agent didn't talk about that, but we know from the other evidence, like how it correlated with what unfolded that day. How there was a different team from New York who was going to come down and rob the Garner K Jewelers. That they were spooked. And then Maynard and Brown said, "We'll do it. Put us in the game." There's a reference, and a lot of the phone calls, a lot of the testimony about the phone call, I'd say probably about half, it was connecting street names and references to people that are mentioned in the phone call to the defendant and explaining like who that was. That Malik was referring to Malik Maynard. That Bless was the street name for Christopher Brown. That Adele was the individual who was known to be the fence at the Four Seasons Mall. He had a jewelry store. So Haas was the individual who was identified as coming down from New York City. So I think that.
All right, so talk about the Four Seasons fence guy. So an expert could rely on that, right? Because an expert can rely on hearsay. But was there admissible evidence that he was the fence?
Yes, the Maynard and Brown both
Had both testified to
had
it.
both testified.
So he's in that context, he's relying on other individuals' witness testimony, which we think about like an expert doing, but do we really think about like a lay witness sort of saying, "Oh, let me pull all these pieces together for you"?
I mean, I think he is testifying about what his investigation revealed to him as to who these individuals were. He does talk about the connections between the people separately, like in his testimony, he talks about who Tamika Lloyd was, who Miss Baldwin was, and that's all information that he gained throughout the course of his investigation. And I'd like the court also to look at, to consider the smaller portion of the testimony that Robertson, that these calls were. I mean, he talked about his background. He linked the vehicles and the license plates to the different locations. He helped to corroborate the trip to New York. He, with the license plate readers and everything, talked about the relationship between the defendant and Lloyd. He discussed the evidence that came in through the pawn shops, linking the slips and the jewelry. He spoke at length about the mail intercept. And then there was this part about the phone calls. And so we have lineup, tools, back room, mission, basketball game. I think that when you look at, in the context of his testimony, I don't think it's necessarily like a clear error that immediately upon segueing into these phone calls, that it should have been obvious that this was not lay testimony, that it was expert testimony. Even as we're discussing it here, I think we're struggling. So I think that goes to show that that the defendant can't meet the plain error test. And at least with respect to the second July call and the October basketball call, there were no objections. And if I can back up a little bit again to the overwhelming evidence. In addition to what we've talked about, we have the surveillance footage. There's the Verizon employee that puts him scoping out the Garner. We have the pawn shop jewelry that was collected from the Greensboro pawn shops, and those were pawned by people who were linked to the defendant. We have the recorded calls, and then we also have very egregious post-arrest conduct. All of this demonstrates that this was a compelling and overwhelming case against the defendant. So even if you were to assume that the victim impact testimony was error, or that this agent testimony was error, it was not prejudicial to the defendant. And that is why we ask you to affirm the judgment of the district court.
All right, thank you. Mr. Maher?
Yes, let me address, a few of these issues. This case, the agent's testimony about the calls, I think, aligned with what happened in Johnson. He reviewed calls he had no role in. As an investigator, apparently got copies of the recording. It is very different, for example, from a DEA agent who's involved in an ongoing investigation of an ongoing drug operation, who's listening to a wiretap or whatever to calls and interpreting drug code. I will say on the X-Men, if the government believed that interestingly, the agent himself said, I'm not an expert on the accident. I understand that he's a leader. Apparently he himself didn't have much knowledge of that. So the calls crossed the line that this court has set forth in Johnson. I will also say, in considering the impact of this, I do believe that the introduction of the agent's testimony is the strongest issue, but it's not the only issue. So if there was error in allowing the victims to testify, not just about how they reacted at the time, but the long-term impacts, and if there was error in allowing them to identify Mr. Walker as the decoy, or give an opinion that he was just acting afraid, all of that contributes. And then you've got Mr. Walker basically being unfairly balanced against his testimony by these opinions and this very emotional testimony. And I will say, for example, that with the first victim, when she described what happened first, the government then said, can you tell us what that means? And invited her to go further, to give this testimony going way beyond what happened in the robbery, and it had the long-term impacts. And of course, as the court has noted, this is a case not only where the co-defendants had guns, it was on video. Everybody could watch what happened. They could see the guns. There really was no question that this was a robbery. The only question was whether Mr. Walker played a role. And so, for those reasons, we believe that this does rise to the level of plain error, and that Mr. Walker is entitled to a new trial. I'm happy to answer any further questions.
All right, thank you. And thank you to both counsel for your arguments today. We hope someday soon to resume our normal practice of coming down and greeting you formally after argument. But until then, safe travels back to North Carolina.
Thank you.
All right, we're ready to hear argument in our second case today, and our last case of the week, at least for the three of us. Cason versus Maryland Division of Corrections. Mr. Weiss, whenever you're ready. Yes, you may. If you're arguing, you may both remove your mask if you're inclined to do so.
Thank you. Good morning, Your Honors. May it please the Court. My name is Samuel Weiss. I represent the appellant, Mr. Mark Cason. I'd like to reserve 4 minutes for rebuttal. I see the clock. Thank you. Mr. Cason has alleged a textbook disability discrimination claim under the ADA. He has alleged that he is handicapped and that a number of the services, programs, or activities of the prison where he was incarcerated are not handicap accessible. The district court, or pardon me, the defendant did not move to dismiss his ADA claim. The district court did it on its own accord without realizing it would appear that it was doing so. It dismissed his claim in a single sentence, providing 2 reasons. The first was that he had not identified any services, programs, or activities
Yes, do we need to even get to those reasons? There's some discussion in the briefs about the relief. It doesn't seem like any of the relief is available to your client anymore. The equitable relief, that there's no pleading that would support damages. And of course, we can't award good time credits.
Right, I think the pleading certainly supports damages. So we can get into sovereign immunity now, Your Honor, if you'd like.
So I think in your brief, you said you agreed with the courts that have said there needs to be some evidence of intentional discrimination to support damages. So yeah, tell me more about the complaint, how it pleads evidence of at least deliberate indifference.
Absolutely, Your Honor. So Mr. Kaysen plainly states a claim of deliberate indifference. In the context of the ADA, the standard of deliberate indifference is knowledge of a substantial likelihood of a violation of a federal right and then a failure to act upon that knowledge.
But they acted on the knowledge. The Department of Corrections responded to his grievance a little over a month after he filed it. They had outside agencies conduct site assessments and found that some of his claims were meritorious and had plans in place to correct those. So how was that being deliberately indifferent?
I think there's 2 points on that, Your Honor. The first is that we have absolutely no evidence whether any of that occurred. And that's why it was inappropriate.
And we don't have any pleading that it didn't occur.
Well, that's true, Your Honor, although I think resolving ambiguities in favor of the defendant and against the incarcerated pro se plaintiff on the Rule 12 stage is not inappropriate.
Well, in any event, your client was moved from that prison in August, so he received a response in May saying, we're on it, we're going to fix this. He was moved from the prison in August, so we're speculating that nothing happened. Seems like maybe something did happen. They did try to fix it, but even if they didn't fix it by August, would that be deliberately indifferent?
Well, for a couple of reasons, I believe the answer would be yes. Although deliberate indifference is a context-specific inquiry, it's typically not fit for resolution on Rule 12. And I don't think Your Honor's characterization of that we have evidence that they took remedial measures is correct. There's no evidence in the case at all. There's only allegations. But a second point on this, which is that.
But to Judge Rushing's point, there's also, speaking of allegations, there's no allegation in the complaint that it wasn't corrected
That's
such that they were deliberately indifferent to Mr. Kaysen.
that is true, Your Honor. And if this court is inclined to resolve that ambiguity in favor of the defendant, I think there's one other very important point, which is that deliberate indifference, the knowledge of deliberate indifference, can also be inferred when a need is obvious. And here, the need was obvious. It could not have been more obvious.
So much so that the warden responded in a timely manner and agreed with Mr. Kaysen and was taking steps to correct all the various challenges that someone with a disability would face in that prison.
Well, I would again say that we don't know if the warden, Your Honor, I think it would be a little perverse if we have an incarcerated pro se complaint saying this facility is not wheelchair accessible in all of these systematic ways. And if defendants were entitled to relief on Rule 12 because they agreed and wrote him back and said, yes, we agree.
Isn't that what deliberate indifference means? Is that if they're not deliberately indifferent, that they're entitled to it?
Well, yes, Your Honor, I do agree with that.
Can I go take a step back here?
Yeah, absolutely.
On sovereign immunity, when we look at the Georgia case, it suggests that we've got to look on a claim by claim basis to see whether it's, they've alleged sufficient plausible facts to violate Title II. Do you agree that in that inquiry you have to show deliberate indifference?
Not exactly.
So help me understand.
Well, for the following reason, and I would like to get back to the point of obviousness at has to state a claim under Title II of the ADA. Deliberate indifference is just a question of relief. So it's just a question of what remedies are available to him. So he needs to demonstrate deliberate indifference to obtain damages. And so this court could find, well, if your equitable relief is moot, if there's no deliberate indifference, this court could hold that that the claim is essentially moot. However, for purposes of sovereign immunity, that doesn't mean that he wouldn't have alleged a claim under Title II, because deliberate indifference is not an element of stating a claim under Title II. It's a limitation on relief.
All right, so you seem to dance around that a little bit, but so at step one of the Georgia inquiry, right, as we sort of think about that, do you have to plausibly allege deliberate indifference?
I think in this case, if the court, I don't mean to dance around it, if this court were to hold that his equitable claims were moot, yes, I think for that purpose. Although this is 6 of one, half dozen of the other, I think it would be properly characterized as him just failing to state a claim.
All right, so, and then let me just make, because you have an if there, and I want to ask, well, how could we find that his equitable claims are not moot?
Well, I think it might be, this court has a general rule that transfer does moot out equitable claims. I think, barring unusual circumstances, the circumstances here are a little unusual. He's alleged that there are only 2 facilities in the entire state that hold people who are in wheelchairs. He's in one, he's not in the other. Again, this is why having some of these issues out of the district court would have been helpful.
But I mean, we've got a rule. I guess what I'm trying to figure out is like, we have a rule that says transfer makes equitable claims moot. He was transferred. Is there a case or a theory that you want us to consider? I mean, I understand your point is, I don't know, maybe he might end up back there because there are only 2, but like that doesn't get you there, right?
Well, yes, fair enough. I think it would be reasonable for this court to hold that it doesn't get us there. I also think it would be reasonable to hold that this is the sort of inquiry for the district court to take on in the first instance. Again, I think if we're remanding.
Well, but you have to tell us what the district court could find or do that would allow it to find it moot, right? I mean, we remand when there's like a debate, right? I don't know, maybe it's moot, maybe it's not, maybe we remand. What I can't figure out is how possibly your equitable claims are not moot.
I'm
Under current case law.
Yeah, I think the current case law is that barring an unusual circumstance, equitable claims are moot. This claims could be an unusual circumstance. I think if the damages claim is going forward, it doesn't matter too much one way or the other, because he very well could be transferred back. If you hold that equitable claims are moot, he could amend his complaint. If he gets transferred back.
Was he transferred to one, you said there were only 2 wheelchair accessible, so he was transferred to a wheelchair accessible facility? Okay, so that may also be another indication that the Department of Corrections was not deliberately indifferent.
It could be, although again, deliberate indifference, in terms of did they fail to act or did they act reasonably, is typically a fact-specific inquiry. It's typically not fit for resolution on Rule 12. I don't think this kind of speculation being held against a pro se plaintiff is consistent with the procedural posture that we're on. I would just like to make one point on obviousness, which is that Judge Richardson suggested, or a couple of your honors have, about, well, he files a grievance and then they do something about it. They didn't know that the facility was not wheelchair compliant, and then he filed a grievance, and then, well, we don't actually know if they did something about it, but they said they did something about it, and isn't that not deliberately indifferent? But it is obvious, not just.
Well, they did, number one, they responded to him fairly promptly. Number 2, they had a number of investigations of the facility to assess whether or not his claims had merit. Number 3, they found that several of them did. And number 4, they had plans in place to correct those.
They claimed that all that is true.
Well, they claimed the 4th one is true. The first 3 aren't accurate.
I don't know how we can say that.
Well, I'm looking at they responded to him.
Oh,
They,
sure.
okay, go ahead.
So just to make a point on obviousness, there are 2 facilities in the Maryland Department of Corrections that house people who are incarcerated. Mr. Kaysen identified a series of structural deficits on the bathroom, the toilet, or pardon me, it's redundant, the bathroom, the shower, the recreation area, the visitation room. These were all structural problems that made it inaccessible to all people in wheelchairs. And this
I
is
think, you know, there might be a point to be made there that if it could be perhaps so obvious, right? Like my clerk and I were talking about, what if a doorway is not wide enough for a wheelchair to get through, right? Like maybe that is so obvious that you should know without anyone having to like give it a try and tell you. But the complaints here don't really strike us that way. There's the table, like certainly it seems like the table height was not compliant or it made it difficult, or the thresholds, but none of these seem to be the sort of thing where we can say, based on the pleadings, everyone should have known that this was out of compliance without anyone ever telling them.
Yes, so on that, I would say it might be a little less intuitive to the average person, like you or me, that is the case.
Or like a warden?
Or like a warden of one of the only two facilities that accepts people, that is designated as a handicap facility, whether people who are entirely reliant on his care can safely use the toilet every day, whether they can safely shower every day, whether they can use the recreation yard, whether they can sit at the visitation tables. It is not only plausible, it is obvious that these accommodations, and again, I think this would be a very different.
So do you think obviousness, I mean, you want to say it should be obvious to an expert in the field, right? But we don't think about obviousness in that way normally, right? We think about whether it's actually obvious, right? Not obvious to, a compliance expert, right? So, yeah, because you seem to concede it might not be obvious to the three of us, but if it's not obvious to the three of us, like, isn't that sort of the standard that we're looking at? Or at least if we're representative of objectively reasonable people, which may or may not be true.
I think that's not right, Your Honor, and I think so for the following reason. That deliberate indifference is about whether the defendant knew. And one way of knowing is through grievance, and another way of knowing is because we are inferring that they knew from the obviousness. And here the defendant is the public entity. It's the Maryland Department of Corrections. As Mr. Kaysen actually noted in his grievance, there are regulations governing the structure.
Well, you're right, but again, I'm stuck thinking, well, how out of compliance was it, right? If there was an allegation that, someone in a wheelchair literally could not use these toilets ever, right? So there's an allegation that this person never was able to use those facilities. That suggests to me they're so out of compliance that it's obvious, perhaps. But that's not what we have here. There's no sort of allegation along those lines that suggests that it would be so obvious to a warden without, pulling out, the tape measure.
Yes, I understand that, Your Honor. I think one example that might be helpful, and this is at J19, is when he's talking about the shower. And, a typical shower is not safe for somebody who is a partial quadriplegic to use. And he alleged that in his grievance, he said other housing units have grab bars. The warden cannot say that he doesn't know that I need this accommodation because the other housing units have them and they haven't installed them here. And so I do think that sort of accommodation, I do think to the warden of a purportedly wheelchair accessible facility.
But doesn't that assume his knowledge that they're not in there? Right? I mean, I don't know. I'm not a warden, right? So this is part of the trouble we have in evaluating these cases, but I'm not sure how often the warden spends in the shower in cell block C, right? I mean, and my guess is, like, not a lot.
Right, that's fair. I'll quickly note that I've been using warden as a shorthand, but the Maryland Department of Corrections is the defendant. So if it's the entity as a whole, and so.
Right, but that's again back to the problem that you've got, right? Is you want to say, oh, yeah, everybody, we're going to use everybody's eyeballs, but then I want you to say what is obvious to an expert warden, not to a normal person, right? I mean, what you can't do is combine those two things.
I understand that inference, although of course prisons are hierarchical
when they're obvious, they do.
They do, and Your Honor, I would submit that the idea that that partial quadriplegics cannot safely use a standard shower, which is why the other housing units have them, would be obvious to line staff. It certainly be incarcerated, it would be obvious to incarcerated people, as well as to the warden, whose job is to oversee the prison and make sure that it's compliant with those sorts of regulations. I see I've used my time for a while. Thank you.
Thank you. We'll hear from Ms. Arnquist.
Thank you very much. This court should affirm the lower court's dismissal of Mr. Cason's ADA claim because it fails to state a claim. The injunctive relief was clearly moot. That is an established precedent in the Rendleman and Kumar case. In this case, it was even more so because in most of the cases that deal with transfer mooting a claim, there's a transfer that happens after the lawsuit was filed. In this case, Mr. Cason filed this lawsuit 6 months after he had already been moved out of Dorsey Run Correctional Facility. The claim for money damages is barred by the state's 11th Amendment immunity. To get to the questions that the court was addressing.
Can you, I'm sorry.
Go ahead.
I am right in reading your brief that you are asserting sovereign immunity and requiring us to rule on it. It's not a conditional argument for you in any way. You don't have a backup argument on appeal.
No, this
Right.
is the argument.
It is the whole, so we have to reach that question.
Yeah, I mean,
Well-
that's, well, actually,
Wait.
no, actually, that's not true, because the decision of the lower court to dismiss it for failure to state a claim is also an alternative grounds.
Right. So since you went straight to sovereign immunity, it made me think that you were conceding that he stated a claim.
No, I'm sorry.
Okay, maybe you could
Okay.
clear that up.
The district court said, construed it liberally, so much so that nobody else involved in the case even really saw it as an ADA claim. But the district court did look at it and said he failed.
It's clearly an ADA claim.
Okay, so the district court looked at it and said it fails to state a claim because, as discussed earlier, to be entitled to damages under the ADA, at a minimum, what has to be established is deliberate indifference. Actually, some circuits say intentional discrimination, but just giving, the lower courts in this circuit have applied the deliberate indifference standard. And the facts as alleged in this case, they show the opposite. There's no deliberate indifference in this case. Mr. Cason brought some structural issues to the attention of the department, and the department thanks him. And the warden immediately brought capital construction out to do audits.
All right, but before we get to the facts, this threshold question matters to me. So we have a case called Constantine that says if you assert both sovereign immunity and a failure to state a claim, we must address sovereign immunity first, right? That we must address that first, unless your assertion of that is only conditional, right? And it sounds like to me, when I read your brief, I read it as saying, no court, you must address sovereign immunity. Do I read it that way, or you not? So we did this recently. Virginia sort of asserted sovereign immunity, and then after argument said, you don't have to address sovereign immunity if you don't want to. I'm just trying to understand, do we have to address sovereign immunity, or are you asserting that as a conditional argument? If there's a claim stated, then we have a backup argument of sovereign immunity. Does that make sense?
Yes, I do understand, and the problem is they're so entwined because part of the analysis on the 11th Amendment.
I totally get it, but I'm asking a pretty formal question, right? Which is, does the Commonwealth demand that we address sovereign immunity, or is their argument on sovereign immunity a merely conditional one?
It's conditional because just on its face, this failed to state a claim under the ADA.
Okay, and so if we ruled under 12b-6 that they failed to state a claim, the Commonwealth does not demand that we address sovereign immunity. You're going to be okay with that outcome?
It failed to state a claim. I'll start with that.
Right,
To state a claim, it has to meet at a minimum deliberate indifference. The facts as alleged are that Mr. Cason filed this complaint. There's nothing obvious at all about the allegations in this part, in the complaint. What's alleged is that there wasn't a shower handlebar, that the toilets were an inch too low.
Right, and so the grab bar, that seems like a relatively easy fix, easy installment. I think I could install a grab bar, frankly.
I don't have any doubt about it.
And
It's not that.
apparently
She
not
is
in prison.
probably the only one of the three of us that could, but,
I think Judge Rushing might be able to.
all right, 2 out of the 3 of us can.
Anyway, so the warden responded in May, acknowledging that some of the claims were had merit, and Mr. Cason was not transferred until 3 months later, and yet the grab bar had not yet been installed by 3 months later. I don't.
We don't know, because again, that's not alleged in the complaint. What would have to be alleged is that I brought these to your attention, even if they rose to a constitutional violation or a significant violation. And what's missing from the factual allegations is you responded and told me that you were gonna correct it, and then you never did. You didn't take any action at all. So the deliberate indifference, you can't reach a plausible case based on these facts. It's the opposite of deliberate indifference. But I'll take the court to the reason that the district court found that failed to state a claim for a different reason, and that was because Mr. Cason failed to allege that he had been denied participation in any service, program, or benefit. He did not. There's no allegation here that he was not able to shower. There's no allegation that he was not able to engage in visitation or that he was able to participate in recreation. The allegations were, and since this is a reasonable accommodation claim, nor was there any allegation that he sought an accommodation or that no accommodation was made to allow him to participate in those programs. So under the plausibility standard.
I mean, shouldn't, when you're dealing with a pro se plaintiff and we're saying he's pointed out that there's a compliance problem and the prison agrees, but we're going to hold him to the standard of saying, well, you didn't say that you couldn't shower, you just said that it made it unsafe to shower. I mean, shouldn't he just be given ability to amend if that's the problem?
Yes, but he never sought leave to amend. He has never sought leave to amend.
Well, no one asked to dismiss this claim. It was dismissed before he knew that there was a problem with it.
But he's not asking you, he's not before this court asking that you remand it so he can amend. He's asking the court to determine that the lower court erred in saying it failed to state a claim. Whether he could have properly amended if he had moved after the decision of the lower court to amend, or said before this court, telegraphed or proffered some additional facts, that would be a different inquiry. But since the plaintiff has not sought leave to amend, or even asked that you reverse it so he could amend, I think an obvious assumption is that he's not able to assert he was not able to shower. He's not able to assert that he was not able to engage in visitation. The allegation is that the table was too low, and so he could engage in visitation with, maybe he was 2 feet further away from his person he was visiting with. That's a far cry from saying you violated the ADA because I couldn't participate in your program, which is the program is visitation, the program is showering, the program is recreation. With regard to the weight pit, he is a paraplegic, and what he's complaining about is not being able to go into one part of the prison and lift free weights. There's no allegation that he's qualified to do that or that there wasn't an accommodation made for him to be able to do that, because he's just alleging that it was difficult to traverse. And I'm not trying to stand on ceremony here. I think this is really at the heart of what your questions were as to whether or not how significant a violation this was. And again, it's not, every violation is significant. I assert that. But in this case, when you're talking about, an abrogation of the state's 11th Amendment immunity and subjecting the state to monetary damages for every violation of this nature, then it becomes a very significant inquiry. And so the district court found he didn't allege that he was denied participation in any program, service, or benefit. Even though there was a grab bar there, he has not said he couldn't shower. And by contrast, the last stands in contrast, because in that case, the court found that there was it had stated a claim because the inmate in that case said very specifically, I was denied participation in the jobs program. I was not allowed to participate in the jobs program. That case is also relevant to the 11th Amendment inquiry because the court found abrogation, but only because Mr. Faulkner had also stated a constitutional claim in his complaint. So I think that the lower court can be affirmed simply on the failure to state a claim under the deliberate indifference argument, and also under his failure to have identified what he was not able to do and whether an accommodation was denied to him. And on the 11th Amendment argument, this is not the type of conduct that is for which the ADA was congruent or proportional, and a proper exercise of the court's of the Congress's authority under Section 5 of the 14th Amendment. And that is because you compare the evil that's presented, and I'm not minimizing it, but the evil that's presented is the toilet was a little too low and I couldn't enjoy the shower, but not that you were unable to shower or that you were unable to toilet. And then you weigh on the other side of that the long-standing deference that the courts owe towards the states in running their state penal systems. And when you apply those in that balancing test, this cannot be a proper abrogation of the state's 11th Amendment immunity under the facts of this case.
Y'all have further questions? All right, thank you. We understand your argument, Ms. Arnquist. Mr. Weiss, you have some time reserved.
Thank you again. I would just note, I believe that Mr. Kaysen has identified programs, services, or activities that he was not able to meaningfully access. As Judge Rushing noted, it's not impossibility of access, it's meaningful access. So things like unsafe access or not meaningful access. He says, I suffered on JA 8 because of the wheelchair inaccessibility. I suffered because of the conditions of the shower. He says that.
But is that, I mean, to sort of get to the sort of, Twombly-Iqbal, like that seems to be the conclusion, not the, facts, right? I mean, if he said, I'm only able to get in the shower by taking these steps, or it creates this danger, but part of the trouble, and I'm not sure we have to get to this, but is the sort of conclusory sort of nature of how he's denied access. I don't think it would be sufficient to just say, I was denied access without helping us understand how. And to say, I suffered as a result seems similarly conclusory.
I understand that concern. I think certainly on its own it would not be sufficient. But what he's done is I'm calling up these few brief moments because they are times that he makes explicit, which is what is obvious, which is that he alleges that he is a quadriplegic and has no wheelchair, and he alleges that there are all these ways that the facility is wheelchair inaccessible. And so if this were a case of something like some sort of individualized, were he to say lots of prisoners don't get hearing aids, and also I'm hard of hearing, that would miss a key part here, which is, what about you specifically? What he's alleged is that he's in a wheelchair and that the facility structurally in all of these different ways, it's not different on Monday than it is on Tuesday. The tables are the same height, the showers have grab bars, but they don't. That he has suffered because of that inaccessibility. So it's true that in some ways involving himself is conclusory in that respect, but it ties into where he goes. So on that allegation, it's brief, but it ties into him later saying the showers, they don't have seats, they don't have hoses, they don't have.
Is this the statement of facts that you're talking about? So he makes the complaint and he has this statement of facts?
Yeah, I'm listing the statement of facts in his grievance, which he attached, which is at JA 18. He lists a number of ways the shower is not accessible.
Well, but in the court at least, he says there is a wheelchair shower and it has a seat and it has handrails, but they're quote inadequate, but for reasons that aren't clear, right? And the same thing with the toilet, right? He says there's a wheelchair toilet, doesn't say exactly what it means, and it doesn't have proper railings, which I interpret to mean it has railings, they're just not the ones that he thinks are required.
Yes. So,
I mean, you just keep saying there are no railings, there are no seats, none of this is there, but when I look at, I'm not sure I can consider it to be fair, but like his statement of facts before the district court,
are you referring to his initial complaint that was superseded by his amended complaint?
I don't think there's an amended complaint. I think there's just like a response that's a statement of facts.
Oh, okay. Okay. Thank you, Your Honor. Sorry, I was confused there. So I think there is nonetheless, he only needs to identify a single service that he's identified several, but even if something like the weight pit, he says, I was unsafe. The failure of accommodation was unsafe for me in the weight pit. That would be enough to state a claim. And I would just briefly say that, some of these issues that we've discussed about, what exactly did they know, who knew it, when did they know, when did they actually act, these are proper determinations the district court to make in the first instance. What we have here is a pro se complaint that is not as sophisticated as it was written by an attorney, but it's sufficient to state Title II.
All right, thank you. Thank you, Mr. Weiss. And thank you both for your arguments today and the work you do every day. We wish you safe and happy travels back up I-95. With that, we'll ask the clerk to adjourn court.
This honorable court stands adjourned, signed, and died. United States